Hello, this is Adam Feinberg, and you are listening to Harlem Stories. And today I'm joined with my co-host, Mark Becker.
Great to be here.
Awesome. Well, today we've got a great story for you today. This is more on the brokerage side of the equation, and just a little housekeeping as a reminder: we're now releasing episodes every 2 weeks. Today we're going to talk about shopping for a transactional attorney, assuming that we're looking from the buyer side. And I think as we're going to cover, I guess, some of the basics on our end today. We're not going to go too deep down. I think what we'll do is in a later episode is we're going to kind of leave that, and we'll bring in an actual transactional attorney, and we'll have them discuss that. But for today, we're just kind of set up the topic and provide at least a little bit of expectations of what buyers should be expecting.
Yeah, and I think it's important to stress, we're in New York. My understanding is for instance, I could be wrong here. If you know, Adam, correct me. But I believe in a lot of states, like for California, for instance, you don't really need an attorney. It's basically done amongst the real estate agents. But in New York, you have to hire an attorney. It's the cost of doing business.
Absolutely, and I actually just went through that with my mother in Florida. There is no attorney. I just couldn't believe how much simpler the entire process was. Not just the contractual side, but just overall the purchase process. It just emphasizes that New York. I've heard the expression is that renting in New York is like buying in other parts of the country, and buying here is unlike anything else in the rest of the country. So, I think that kind of sets the tone. But at the same time, I don't know. I can say, as an owner, I feel it was worth it. It was a little extra effort, but it was definitely worth it.
Buying here is like a proctology exam.
Well, it all depends on the type of transaction you're doing too. Because if you're doing like a condo sponsor deal,
that can sail right through.
Yeah, that can sail right through, and that's much more like doing deals in the whole rest of the country. But yeah, absolutely, these things can be real tough. Exactly as you said, that every deal in New York City requires an attorney. We recommend a transactional attorney that specializes in real estate transactions. And, the reason for that is a lot of times we get, clients that say, oh, wait, my Uncle Joe, he's an attorney. He can do this. Our response to them is, yes, he probably can. However, the attorneys that are transactional attorney real estate specialists in New York City, they do this every single day. They know what to look for. Your Uncle Joe can technically get it done, but the question is, does he know exactly what to look for? Because he might not be doing this on a day-to-day basis. So for that reason alone, it may be worth it not to just hire a generalist that does this from time to time, but rather hire an expert. So what does a transactional attorney do? And I think this is what a lot of our clients are really asking. I'm like, they don't really understand the process. And fair enough, because this is the type of thing that you're not going to know about unless you do on a regular basis, and we do. So once an offer has been accepted, and personally, I like to prepare my clients and say, select an transactional attorney, real estate attorney, early on in the process, so that way when we do find you the right home, you're not scrambling in an emergency basis trying to find the right person
and end up hiring your Uncle Joe.
Yeah, exactly. So the ultimate thing is I want to prep my clients in advance, have that transactional attorney. But not only that, I think it makes an offer stronger if you're able to tell the other side and say, hey, listen, my client's already found an attorney that they want to use. We're raring to go. I'm like, there's not going to be any delays because, they didn't know to look for this process. So that's certainly a recommendation that I provide. But once an offer has been accepted, the agent should provide both the buyer and seller's attorney a deal sheet with the terms of the offer. So, I think that's an important component of it, just immediately having that, contact information all raring to go. What we have is created called a deal sheet, and it just kind of lays out all the information, between ultimately buyer and seller. The buyer's agent, often is only going to fill out the buyer side, and the seller, then the seller's agent will pick up the slack and fill in the rest and send it to all the different parties. And it's just like, contact information, the terms of the deal, buyer information, seller contact information, the contact information for both buyer and seller, attorneys and brokers as well, and any other specifics of the deal. So the contract, what they wind up doing is the contract and due diligence phase should ultimately occur simultaneously. The sales attorney is going to be working on filling in the details on the deal sheet into the contract, while the buyer's attorney starts the due diligence process. And the process should take roughly 5 business days, give or take. I mean, sometimes I've heard of some of these things coming together in a couple days in a hyper-crazed market. That is not the norms, I would say, though. Would you say about 5?
Yeah, I think. Yeah, I always tell people 7 to 10 days, or the equivalent of 5 business days. And if you are a buyer, keep in mind that period is when the listing agent is likely to be scrambling for a higher offer. So you want to get that contract signed quickly. So make sure your attorney moves efficiently.
Yeah, and I'd say that's that's an important point, is making sure that you have and this is another reason to go with somebody that is really experienced and knowledgeable and does this every day, because they understand that speed is an important point in this equation. And ultimately, even though I'm saying it might take 5 business days, the reality is on the buyer side of the equation, and this is often just outside of the range of control, it often takes longer, especially the building's managing agent is not fully cooperating, which unfortunately, due to, some of it is the people that are covering that, but often that's not the case. It's not that they're lazy or not trying to do their jobs. A lot of times it's because there may be legal questions that they don't know the answers to, and they don't know how to answer appropriately. So they might be taking their time and consulting with others, before they get back and give a response to the attorney. So a lot of times these questions that the buyer's attorney is asking of the managing agent can't always get an answer right away. And sometimes it's the individual managing agent, and we go under the recognition that sometimes that they're overworked and underpaid. And
my suggestion to agents out there, or buyers, if you're working with an agent, you really got to kill them with kindness and attack them from the north, south, east, and west, because sometimes, as Adam alluded to, you get a real gem at the management company and someone who's super cooperative, and sometimes you kind of get someone who's taking advantage of the work from home scenario, who's probably knee deep in Fritos and Mountain Dew and video games.
Well, that all sounds actually quite relaxing, though. But yeah, so in some cases it's just like, or it could be like the building hasn't provided that much information. So it could be like, for instance,
questionnaires,
the questionnaires, and or going through the meeting, the meeting notes, and going through that. And I can tell you, there are some buildings that actually do not provide anything other than, we met, these are the people that were here, this is the time we started the meeting, this is when we adjourn the meeting, and that's like the meeting minutes.
Right.
So, sometimes, it is tough to gather information when you have a building that, that does that. But there's going to be managing agents that actually suggest that approach. So understand, trying to get answers on the buyer side is sometimes very difficult, not necessarily because the managing agent is trying to be difficult, but because, the building has taken certain legal advice and said, what, it's just better as a general rule of thumb for us to provide very little information.
And just to remind people, if you're really having a tough time getting a hold of the managing agent, I do not suggest finding out where they live and lying in front of their car. But if it has to come to that, do what you got to do.
Well, I can say I've actually had to track down another attorney by going to their office. I don't like doing that.
Especially for an imposing guy like you, Adam.
Yeah,
That can be
exactly.
intimidating.
I'm a short, fat, balding guy, but hey, you know what? None of that matters
You
because
are pure sexy. Come on.
oh, I don't deny that, but but I mean, I'm not exactly the most intimidating looking, but man, I can be a beast when
You're a
when
pistol.
you. Yeah, so I'm all animal there, but all right, back to our topic. So all this should start occurring simultaneously with regard to both due diligence and the contract. The seller's attorney, they're going to be spending time completing that contract. They're going to be filling in the details specific to the deal, though it's mostly boilerplate until the buyer's attorney reviews all the due diligence materials, and then there will be some negotiations between the attorneys of both sides.
Yeah, I think the only really as you said, is mostly boilerplate. You want to look for a mortgage contingency, meaning if the buyer gets denied a mortgage, they still get their down payment back. And like you're alluding to, the riders are really what you want to focus on because that's going to be the overriding language.
Exactly, and you actually just hit upon my next point over here, is that even though much of the contract is boilerplate with minor changes in most cases, the specific details or aspects that an attorney wants to see in the contract is typically going to be in that rider. And both the buyer and seller attorney typically negotiate on some details in that rider. So yeah, you look at the contract. REBNY offers a version, and I've seen other versions that are non-REBNY. But for the most part, they're pretty boilerplate when you look at them.
Surprises.
Yeah, and most of those contracts, there's very little change. It's usually the riders at the end. So. And then, of course, the specifics regarding this deal and, those contact information, things like that. So the buyer's attorney due diligence, that's really where most of this process really focuses on. It's a multi-step process in what they're actually doing. And, buyers are often wondering, well, I'm paying a few $1,000s for this attorney. What are they doing? And, not every attorney necessarily will go through and explain what all the steps are. They're just saying, listen, you need me in the process. Let's get to it, and I'll walk you through it as we go. But a lot of them don't necessarily explain in advance. So important to understand, among the things that they're going to be doing, they're going to be reviewing the building's meeting minutes, which I mentioned earlier. And this should be scheduled on the first business day, as it's almost entirely done at the managing agent's location, or at least it was that way prior to COVID. And sometimes appointments can be limited to their availability. So now that the pandemic is over, I think it's kind of hard to put that change that back up to the way it used to be.
Yeah.
In terms of, going to the managing agents physically. Now, a lot of times it's done on an honor system. They might send you those meeting minutes electronically. But yeah, a lot of times that is, a very sensitive topic. Review of the meeting minutes, it's essential because it gives you some inside information that might not be otherwise available, regarding issues in the building. And it's also the reason why many buyers opt to not do an inspection of the apartment, because the minutes reveal any reported problems in the building. And this review can raise issues that are addressed in the rider to the contract. So, that's an important reason why a lot of people are going through the meeting minutes. They're going through all these things, and they're wondering, I'm like, well, why shouldn't I have an inspection done? And just so that every listener is aware, is that, as a buyer, it is your right, if you wanted, to have an inspection done. But that said, in most cases, I'll go to my buyers and say, listen, this is going to be a fairly standard condo building. You can hire an inspector. That's your option. My feeling is, because they're not likely, I've done a deal in this building, they're not necessarily likely to get access to building mechanicals. So a lot of times it's going to be from the walls in of your particular apartment.
Right.
And a lot of that stuff we can go and visually start looking and inspecting. Usually when you're hiring an inspector, it's more for the building systems than the specific apartment.
And I want to say something that I learned recently as an agent, and it sounds very counterintuitive, but I actually think building inspections are most valid on new development. Now, why am I saying that? I had a condo deal recently where it was a new development building, and a lot of the systems were frankly not working. And again, it seems counterintuitive. Oh, it's new development; everything's got to be working. But if you have a construction manager who's a little bit lax on certain things, then hey, this brand spanking new dishwasher that you can be in Beijing, China, and start a load of dishes with your phone. Hey, if that doesn't work, that's a problem. Whereas with older buildings, the mechanicals are so established that if there were issues, the building's likely already on top of it. So just food for thought there.
And it's not necessarily counterintuitive either, because number one, I think your point is valid, and I actually went through that. Buying a new construction that was poorly constructed, it wouldn't have made a difference in whether moving forward or not. The timeline was such that even if I had an inspection done, it might have made a difference whether I moved forward or not, but it wouldn't have protected me once I actually had a deal in contract.
Right.
So from that aspect, it could or it couldn't. It doesn't matter from that aspect. But there are going to be situations where I do recommend an inspection be done. New construction, usually more in the smaller, less known developer, but not always that's going to be the case. Or it's going to be in small buildings, under 10 units, where I recommend it.
Absolutely. Not to throw anyone under the bus, I won't mention specific address, but Adam, you're exactly right. That was exactly the scenario. We were in Brooklyn, somewhat deeper into Brooklyn.
I was gonna say, let me guess Brooklyn. I'm like, because
it was a new development building. There were only about 6 units in the building, and it had massive mechanical problems. And we didn't do an inspection, and that was a real lesson to me as a broker.
Yeah, and not to pick on Brooklyn at all. It's just more the nature of the way the buildings are in further out, especially as you get a little further out from Brooklyn, where you're not dealing with high rises or even mid rises. You're dealing mostly with low rises. Where they're like 3-4 stories, and they might be
literal ground up construction where the developer bought a plot of land, scraped whatever was there, and then threw up something new. So it's all brand spanking.
Yeah. So, and the other aspect that I want to mention, with new construction is there's no track record there. So it's not like you're going back to the meeting minutes. And while everything might be new, you're trusting that the developer hired competent people. So, or even, that they didn't get, things that were just deeply discounted because they were iffy whether they worked or not. So, yeah, that is certainly a key aspect of it. And certainly if you're buying a townhouse, you need an inspection done because it's not like there's a board there, there's no managing agent there,
Right.
So, there are going to be situations where absolutely I recommend it. But
you're buying a townhouse, you're already spending $20 million. You might as well drop the $1,200 for the inspection.
Well, it's going to be more, but yeah, I mean, honestly, yeah. I mean, if you're talking big budgets, of a townhouse, absolutely. And,
relatively speaking, it's a drop in the bucket.
right, exactly. So you really want to know what's going on there. It's like even if you're not a fussy buyer and you're like, I'm like, okay, I know certain things need to be fixed. You want to at least know what the true condition is, before you move in.
Absolutely.
All right, so on that aspect, there's the meeting minutes. There's going to be especially, and again, this goes back to your new construction aspect, but versus existing buildings. But you want to be able to review the last 2 years of the building financials. Obviously, you can't do that in new construction, but there's other things in new construction you'll have to review. Review of an alteration agreement or decorator agreement if it's available. Most buildings have an alteration agreement in place, and it highlights some of the rules that the building has set for renovations. For example, days and times when renovations can occur, service elevator access by contractors, fines if renovations are not completed within a designated period. And that's something that's actually really important to note. You want to know that as a buyer, because like what happens if, and I know there's some, like for instance, Upper East Side co-ops, they might only permit renovations to be done on like 1 or 2 units at a time, and it might only be during the summers.
Right.
so depending on the
Read
building.
that fine print.
Yeah, so this is something that's really important to understand, that alteration agreement, or if you're time limited and let's say they only allow renovations for up to 6 months, what if you're 6 months and 3 days? I'm like, those fines, from the building could be, pretty substantial.
And again, another reason to keep it diplomatic with the management company, even as frustrating as they can be sometimes, or that process can be, because once you close, then you're going to have to deal with the alteration agreement if you're doing alterations, which I would say, probably 50% of buyers are doing some kind of alteration, right?
Yeah, I mean, whether it might fall under more of like a decorator agreement, which,
Sure.
just so our listeners know, they might not have heard these terms before. The alteration agreement is usually more for like higher level things, whereas a decorator agreement might be things like, you're changing. You're painting, or maybe you're upgrading the electrical panel, with minor changes,
Stuff that's not going to make a ton of noise or really interrupt anyone else in the building.
Right. Maybe you're changing the cabinets, but you're not really doing anything.
Couple of screws here and there.
Yeah, I mean, but you're not doing any real big renovations or anything of that nature. So yeah, the decorators agreement is going to fall under that category. So the attorney is also going to be reviewing the house rules. So is there anything in the house rules that are unusual that need clarification? So, some of the more common stuff is like a lot of buildings that, because of the fact that we're vertical living over here, they might require carpet or rugs on 80% of the exposed surface area, to limit noise complaints. That's one of the most common reasons for that. And I'll tell you, I hear a lot of buildings have that rule in place, but they don't necessarily enforce it until there's a complaint.
Again, just to capitalize on that, especially when I did a lot of rentals, people will pour through the lease and say, wait a minute, I have to have 80% of my floor covered with the carpet. I said, look, it's not enforced unless you get a drum set. Don't worry about it. Just don't make a ton of noise. Leave your tap shoes at the dance studio, and just as Adam said, it's not enforced, but just keep it in mind that if you're gonna make a lot of noise on that floor, that they do have the right to refer to it.
And it does actually come to the quality of the construction. There are some pre-wars that are built like, just like steel and just like nothing is going to bother you. But then there's other pre-war buildings where I've had where, quite honestly, if you walk, just the simple motion of walking, and you'll hear it in the apartment below. And, I've dealt with that with a client. Ironically, the person living below my client is actually a broker that I know. So some of the noise complaints there, and she actually did put down she put down a rug, covered 80%, and there's still noise complaints there for, so it really depends on the quality of the construction. But, in terms of reviewing the house rules, you might have some other situations such as buildings requiring you to use service elevators for dogs or things like that. So, that's another component. Going on to the next thing that your attorney is going to be doing, they're going to be reviewing the building bylaws and the proprietary lease if it's a co-op. So these are the laws that govern the building, and for the most part, they're really just looking to make sure that there's nothing that stands out that a buyer should need to know about. Now, this is not going to apply to most buyers, but if you're buying an HDFC, there's going to be the review of a regulatory agreement, because typically that's going to govern on how much longer that the building is required to report certain things and to remain as income restricted, but at the same time, they can remain income restricted after this agreement ends. But a lot of the things are specifics of that are spelled out in that regulatory agreement. And one of the more important things in this whole process for a transactional attorney they're going to do is follow-up questionnaire. It's optional. They don't have to do it, but and in some cases, they might not do it intentionally. And, because let's say if it's a new construction building, a lot of these things are just going to be answered in the offering plan. But, maybe there's been an issue that's come up in the past, and they still want to ask that questionnaire. So but it's typically one of the most valuable pieces of information that the buyer's attorney is going to be doing. They'll likely have some follow-up questions, and even after that, they get responses that review all of the items above. And a lot of these are typically proprietary questionnaires that they're creating themselves, but a buyer should ask if they have specific concerns, if the questionnaire or any other communications are covering those concerns. So, for instance, if you know that there was a leak from the apartment above, the building has since fixed, that leak, but they just want to make sure that the building has done all the proper things, to ensure that's the case going forward. Well, that might be included in that questionnaire as a follow-up question. That's not part of their routine questions.
Right. And also, you don't want your attorney to be overzealous, but I would also encourage buyers that if they rubber stamp it too quickly, make sure you follow up with your attorney and say, okay, are you sure you're comfortable with all these terms, or is there anything we need to discuss? So buyer beware in that regard.
Right. So your attorney can do all this research, but if you're not providing them all the right things that they need to be asking for your specific situation, there's only so much they can do to protect you. So it's important, if you have any concerns about this, purchase, whether it's something on the mortgage side or, something with the individual building or, or the purchase type, let's say you want to put it into an LLC. These are all things that you should be discussing with your attorney. Once your attorney has reviewed all the materials above that we just mentioned, the contract and the rider is modified, and this might include some negotiation by both buyer and seller attorneys. The process isn't always as linear as I described, but it's intended to give you a good idea of the ideal situation. And once that contract is finalized, the buyer signs the contract. They provide then the 10% earnest deposit, as is the norm in most New York City resales, and that's applied to the overall down payment. So, depending on what you're buying, for instance, if you're buying new construction, developer might have a specific schedule in which they're looking for, you might be able to put a certain percentage down initially at contract signing, but they might have additional schedules where they're looking for you to put down progress payments.
Right. Keep in mind, again, talking about new development, often, I think maybe we'll get to this later, but often sponsors, sponsor is really just a fancy word for the developer, they will ask the buyer to pay transfer taxes and attorney fees. So you want to make sure you dot your I's and cross your T's there if you're buying new development.
Yeah, or even if you're buying from the sponsor, in this case,
sometimes estate sales as well.
Right. So in the case of the offer I put in yesterday, the situation was it was a rent-controlled, rent-stabilized building that's converting units individually one by one into condos. But in this case, the sponsor or landlord or developer, all interchangeable in this specific situation. In this case, I did ask for the seller to pay for their own transfer taxes and their own attorney fee. So, you're going to have different situations where that could be successful or not. I've done multiple deals in this building with this sponsor and sales team. So even though there's multiple offers, I think we stand a better than average shot. I've actually sold 10% of the units in the building. So,
and often that's an interesting litmus test. For instance, there's a unit at 69 Bennett Avenue. You're probably familiar with that.
Actually, I just put an offer in on one of the other buildings from that same developer.
Right. So that it's a slow market, and often when you're looking that far uptown, you're going to have more negotiability. So I was calling on behalf of my clients to this unit in Washington Heights. It's a condo sponsor unit. So again, as Adam was talking about earlier, it's easy to sail through right there without much rigmarole from the board, because there's not really a board. And I asked the broker, I said, before we make our offer, is the sponsor expecting us to pay transfer an attorney? And her response was, it's a negotiable item. So that can often give you a sense of how desperate they are to sell, and it's a nice little litmus test question that I like as a buyer's broker.
Yeah, and that's, that particular building is part of a much larger portfolio, and I've sold a lot in that portfolio. So in any case, yeah, that that can give you a reasonable sense of all that. So once the attorneys have all done all of that, the contract's finalized. The buyer then signs that contract. They provide that 10% earnest deposit, and then it's applied to the overall. Now, in a building like that, like 69 Bennett, now because the sponsor owns so many units, the actual norm in that situation is actually 20% down, because the sponsor owns so many units that in order for banks to finance, they want to see higher down payments. But
understood.
Yeah, but that's not going to be an all the time thing. So then the seller, they countersend the contract, and then the contract is delivered to both parties. And now, finally, once it's delivered to all the parties, it's now considered to be fully executed or in contract. For resales, once a buyer is in contract, this typically starts the point where the buyer finalizes selection for a lender, and then they start a purchaser board package. But the transactional attorneys still have work to do. They're going to wind up coordinating with the title companies. And this has kind of become like a norm, but it wasn't necessarily a requirement in the past. But I think it's become so accepted that it is expected that the attorney will coordinate with the title company. The attorney on the other side of the deal, they're going to be working with managing agents and bankers if the financing is involved or a mortgage is being paid off. So these are some of those common other steps that an attorney might be doing. And ultimately, at the end of the day, they are also the ones that are calculating out the final numbers for closing costs. So as an agent, I'm often asked these numbers, and I could give the buyers a reasonable idea of what they are, but only the attorney, because they're working with the bankers and all that. They're the ones that are actually going to know those final numbers. So a lot of buyers are asking me, like, how do I shop for a transactional attorney? So I don't know all the answers here, but I can at least, ask, some, or at least help buyers prepare to ask some of the right questions, at least to get kicked off. And there's going to be obviously things that are going to be specific to every buyer that, it's not going to be included in these questions. But here's some good questions to kind of kick that process off. And ask the attorney, where do you primarily do most of your work? So, you want to make sure that you have somebody that's primarily New York City real estate experience. It's fine if they have experience in the suburbs or in other states, but you want them to know that New York City market specifically. You wouldn't want to hire an electrician to fix a toilet. So, the best answer is just, focusing on real estate law and focusing mostly in New York City.
And one thing just to remind people, one of our favorite expressions in the business is buyers are liars and lawyers are destroyers. I had some clients recently that they actually have a board interview tomorrow. That reminds me, I need to call them and prep them for that interview. But they're buying in a land lease building, and land lease is a totally different subject. I assume we'll cover it in a future episode. But Suffice to say, there's a little bit of an added risk in buying in a land lease building because the co-op doesn't own the land upon which the building is constructed. I called my attorney that I usually use, and I said, hey, I got a new deal for you. And she said, what is it? And I told her the building. Again, I won't mention it now, but I told her the building address, and she said, well, that's a land lease. I would never suggest someone buying a land lease. And it was at that point I kind of gave her we have a bad connection, click, and I called another attorney. So you want to make sure that the attorney themselves doesn't have any preconceived notions about the building that could kill the deal.
Right, and I know one of the attorneys that we recommend quite frequently. I know he's owned in a land lease building himself, so obviously, you want somebody that really knows that kind of stuff. And I've seen land leases that are very risky. I've seen land lease buildings that are actually pretty safe.
For them.
Yeah, so the reality is, I'm like, it's like every other category of building sale. There's degrees of severity and everything, and not everything is what it seems.
It's like anything else. You want a can-do attitude from your attorney.
Right, and it might be, unless they specifically know that specific building and they're like their comments are related to that building, right. and they've recently dealt with it, because let's say they've dealt with a building a few years ago. And a lot could have happened in the last few years. So sure. That's one of the things that the attorney due diligence is going to do, because let's say even if it was recent and it was 3 months ago, they're still going to go through that same process of the due diligence. Just their period, their look back period is much shorter. It's really only been, let's say it was 3 months ago that they last dealt with it. Their look back is in that case only going to be the last 3 months, but they have their notes from the last time they did a deal there. So obviously they're judging on what they already know plus the additional 3 months.
Good point.
So some other questions over here. What do you look for in doing due diligence? And due diligence, just to get back to basics, it's the period once the contracts are sent out, and you typically have, let's just put the number out there of 5 days to review the offering plan, minutes, and financials. I think in practicality, it's not really 5 days, but that's the goal at a bare minimum. And your buyer's attorney should be reading the financials for at least the last 2 years and the minutes for the last 4 years. And not have a paralegal do it. They should be doing it themselves. So, for buildings less than 5 years old, your attorney should be reading the offering plan. They should also send a questionnaire to the managing agent asking about the reserve fund, the percentage of owner-occupied units, issues around leaks, noise complaints, bugs, maintenance arrears, proposed building repairs, and things of that nature.
Anything that's going to affect the building bottom line.
Yeah, absolutely. And, the next question, how do buildings in New York City generally run their financials? So, for a buyer that's not doing this on a regular basis, they want to kind of, have a line, to kind of set the bar at, to set expectations. So, just as helpful information, most buildings in New York City usually run close to net even or slightly positive cash flow before depreciation. Too much over, and then they ask if they should lower common charges. Too far under, and then they're at financial risk. So there are exceptions to this, but this should be a good reason. And I think this could be changing a little bit more due to rule changes as a result from that Miami Surfside building collapse. So, I think that's kind of changing the way that buildings are reviewing these things and looking at it. So certainly an attorney might be asking questions around these types of issues. Next question, if I was a buyer, what would I be asking? What clauses do you add or fight for in the contract to protect the contract deposit? So I think that's certainly an important one. Next, will I be working throughout the deal with you or one of your staff? So you want to kind of set that expectation. What items should I be mindful of when financing? So, when I was talking about earlier, the, buildings that have, high number of sponsor units or high numbers of individual investors, these things might impact financing. So, I can tell you in my building right now, and obviously this can and will change over time, my building is more than 50% investors. So, it doesn't necessarily make it the easiest for financing at the moment. And, that could change and flip over with just one sale or one person actually moving back to the States and moving back to New York and reclaiming their unit. But, there's certainly something that, should be of consideration. Next question, does your firm operate as the bank attorney for any particular banks? Because that could be useful. It could also save them a little bit on the closing costs too. So a lot of the attorneys are also bank attorneys for some of the main banks that do loans in New York City. It just makes the process so much smoother and easier on the back end of things that you're not going to see, but it will just make the deal overall easier. If they do use a lot of do a lot of bank work, it also means they do a lot of Manhattan real estate, and this is a focus of their firm. So that's really helpful information to know. How much are their fees? What is your retainer? What circumstances is the retainer refundable? Do the fees include due diligence? So for instance, an attorney might have to lay out cash to send the managing agent a questionnaire. So a lot of times, that's not going to be a refundable. But what happens if, due diligence, turns up things that the buyer doesn't like and they decide not to move forward? So a lot of times they might be asking them like, well, what happens if I don't move forward on this deal? And a lot of times the attorneys will, provide some credit or full credit. It all depends on the attorney on how they want to handle it. Some might charge like a flat rate fee if it doesn't go through. Every attorney is going to be different on how they handle that. And then, a few more additional questions. At what point should I contact you in the process? And, especially if they've heard silence for a while. What is your best piece of advice when purchasing New York City? That might be a good question, for them, since they're seeing so many deals. When will you not be available? I think that's when a lot of buyers forget to ask, because what if they're religious and they're not available on a particular day, because of religious observances, or what do you charge at contract signing, upfront, at closing, partial? So I think these are some important points.
Yep.
Finally, last point I want to discuss is, and we can have an attorney kind of fill in a lot more blanks here, in a future episode. But how can an attorney save a deal? And there are lots of situations where we can come up that threaten a deal. As you mentioned, there are attorneys that will intentionally or unintentionally wreck a deal. I had one attorney that I was going through in one building, and we were going to ultimately between 3 different buyers. We had 4 accepted offers through 3 different buyers. And ultimately, I recommended the same attorney for all because I figured it'd be very efficient and expedient. And the attorney messed it up, and we almost lost all 4 deals. Woo. So, certainly, we've had attorneys that could be deal killers, and in that case, we were able to save, all 4. But certainly you're looking to your attorney to help save a deal for you, correct. And that's where the vetting is really important, and that's why we have some of our favorite attorneys that we'll recommend on a regular basis is because we've seen them actually work proactively over there. Right. So some of the more common scenarios, financing, it's the most obvious. And a good agent might be able to rush through and finding a banker that can approve a deal if the buyer desires as much. But a good attorney also, what happens if the deal isn't going to go through? You lose your job and you need to back out. And ultimately, it's not as easy as, I didn't get approved by the bank, I want my money back. Sometimes a good attorney can help save you and get your earnest funds back. Mm-hmm. So that's one example. I actually had a buyer approved at a board interview, only to be told by the board president that and this apartment actually had a private terrace attached to the apartment. But the board president told her to use the private terrace at her own risk.
Well, that's something you definitely don't want to hear.
Yeah, exactly. So
if they're saying use the dishwasher at your own risk, you'll live with that.
But to use the outdoor space, that gives me images
I'm on
of
the 38th floor,
That gives me images of, especially because this one was a ground floor unit over here, of like bricks falling on my head or something like that. Because the building was known in that situation. They did have a lawsuit against the developer, for construction defects. That much we knew. but they didn't disclose the full extent of everything that was going on until that board interview when my buyer was approved. So ultimately, what wound up happening is my buyer ultimately did wind up going through. The board president kind of blew it out of proportion, but we couldn't get much transparency. So not only were we able to, to save this deal, and that was a combination of my hard work and the attorney's hard work in two different aspects.
That had to have been a tough conversation with your buyer.
My buyer was actually a prosecutor, and so that definitely not the right person, or maybe it is the right person.
Take your Xanax.
Yeah, so that wasn't easy, but ultimately we wound up getting the buyer some savings off on the deal as a result of what wound up happening there. So that's one way over there, and the attorney helped negotiate that. And then, with me having board experience, and her sister and all these situations, ultimately we wound up getting it worked out. But that's another situation. Another case, the buyer's attorney got the sale closed after the sellers. They were recently divorced, where the husband refused to pay child support or any other bills once the sale entered contract, resulting in over 40 liens that were still not resolved hours prior to closing. At the closing table, the attorneys got those liens resolved at the last minute. 40 liens at the last minute. It resulted in a longer closing, but the deal got done, and it was thanks to the hard work of and good work of the attorney. Finally, my last point before we wrap up this episode: if a buyer wants to slow closing or potentially exit the deal without loss of the good faith deposit or myriad of other issues, this is where a good transactional attorney can drown or thrive. So, ultimately, I think next time we discuss this kind of issue, we'll bring in a transactional attorney and, kind of get their take on it. But, from the broker point of view, this is actually what we know is actually happening behind the scenes. And, obviously the attorneys can dive in deeper on these topics. But, thank you for joining us for another great episode of Harlem Stories.
It was a lot of fun.
Thanks.